If you own a home and you are over 60, there are 6 documents that stand between your children inheriting that house cleanly and losing tens of thousands of dollars, or the house itself inside a courtroom. Most seniors never file these documents. Not because they are lazy or careless, but because nobody in the system ever told them these documents existed. And I want to be clear about something right up front. You did nothing wrong. The system just does not tell you this. By the end of this video, you are going to know exactly what each document does, what it costs to file, and the order to handle them in. The fifth one on this list is the document that 9 out of 10 seniors never hear about until their family is already sitting in front of a judge watching a stranger decide what happens to their parents' home. We will get there. But first, let me explain why this is happening at all. The American probate system was not built to protect families. It was built to generate revenue for state courts and fees for the lawyers who work inside them. Every single year, hundreds of thousands of families lose enormous sums, sometimes the entire value of a home, because no one ever handed them a piece of paper that would have prevented it. Most of these documents cost less than $200 to file. Some cost nothing at all, but if you do not know they exist, the system takes the money you meant to leave your children, and there is nothing your family can do to stop it once you are gone. Let's walk through this together, step by step. The first document is the one that determines whether your children pay somewhere between $9,000 and $21,000 in court costs or pay absolutely nothing. It is called a transfer on death deed, sometimes shortened to TOD. It does one thing, and that one thing is the most important thing on this entire list. It lets you name in writing exactly who inherits your house the moment you die, and it does that without ever sending the house through probate court. Here is why that gap matters so much. The average probate case in this country costs a family between 3 and 7% of the total estate value. On a home worth $300,000, that works out to somewhere between $9,000 and $21,000 in attorney fees, court fees, and executor fees before your children can even touch the title to the house. And the money is not even the worst part. In many states, the probate process takes between 9 and 18 months to complete. During every one of those months, the house cannot be sold, cannot be refinanced, cannot be cleaned out. Property taxes keep coming. Homeowners insurance keeps coming. If there is a mortgage, that keeps coming too. All of it out of your children's pockets while they sit there waiting for a court to give them permission to handle their own parents' property. A transfer on death deed eliminates that entire process. You file it once with your county recorder. When you die, the house transfers directly to the person you named. No court involvement, no attorney fees, no waiting. The filing fee in most counties runs between $20 and $60. The deed is available in roughly 30 states. To find out if your state allows it, search for the words transfer on death deed and the name of your state. But here is the one hard truth about this document. It only works if you file it before something happens to you. This is not a form you schedule for next year. The second document is only available in 5 states. And if you live in one of them, the next 2 minutes may be the most important thing you hear all year. It is called a Ladybird deed, and it is available in Florida, Texas, Michigan, Vermont, and West Virginia. A Ladybird deed does something a transfer on death deed cannot. It protects your home from Medicaid estate recovery. Here is the situation that wipes families out every single day. If you ever apply for long-term care Medicaid in your final years, and a significant number of seniors do, the federal government has the legal right to come back after your death and force the sale of your home to recover every dollar Medicaid spent on your care. On a typical 3-year nursing home stay, that figure runs somewhere between $240,000 and $360,000. The government can pull from your estate. A Ladybird deed removes the house from your estate the instant you die, which means there is nothing left for the government to recover. Your children inherit the property free and clear, even if you spent years on Medicaid coverage. But the Ladybird deed must be filed and recorded before you ever apply for Medicaid. If you wait, the Medicaid look-back rule cancels the protection entirely. So if you live in one of those 5 states and you own a home, this is a conversation to have with an estate attorney this month. Now, before I get to the third document and the critical mistake that causes people to throw away everything they just paid for, let me tell you about a resource I put together specifically for situations like this one. Everything we are covering in this video, the deed transfers, the Medicaid recovery threat, the trust mistake that voids the whole thing, the power of attorney window that closes without warning. This is exactly the kind of information that needs to sit somewhere you can return to, not just watch once. I put it all together in the Hank Sullivan Retirement Protection Pack, and you can access it right now 2 ways. The link is in the description below, or you can scan the QR code on the screen right now. It goes deeper than any single video can, and it is built for the exact decisions you are facing as a homeowner over 60. Grab it while we keep going, because we are about to get to the document where families make a mistake that costs them every dollar they spent, and they do not realize it until it is too late. The third document is a Revocable Living Trust. It costs more to set up than the first two, typically between $1,500 and $3,000 depending on the attorney. But here is why it is worth that investment. When you place your home inside a Revocable Living Trust, the house no longer belongs to you on paper. It belongs to the trust. You still control everything. You can sell, refinance, or move whenever you choose. Nothing about how you live changes. But because the house is technically owned by the trust and not by you, it is not part of your estate when you die, which means it cannot be touched by probate. On a $400,000 home, that single move saves your family between $12,000 and $28,000 in probate fees. But the trust does something even more valuable than that. It gives you specific written instructions for exactly how your home is handled after you are gone. If you have 3 children and one lives in the house while the other 2 want to sell, the trust spells out what happens. If you want your surviving spouse to stay in the home for the rest of their life and then have it passed to the children, the trust can do that. If you want to shield the home from a future divorce involving one of your children, the trust can do that too. A will cannot do any of those things. A will gets read in a courtroom and a judge decides a trust is private. It bypasses the court entirely and does exactly what you wrote. Here is where people destroy everything. The most expensive mistake American families make with a trust is creating one and then never transferring the house into it. The legal term is funding the trust. If the deed to your home was never updated to show the trust as the owner, the trust does nothing. The house still goes to probate. Every dollar you spent setting it up is gone. So when you establish a trust, the very next thing you do the next week, not the next year, is file a new deed, moving the house out of your name and into the name of the trust. Skip that step, and you have paid thousands of dollars for a piece of paper that protects nothing. Social Security rules, tax thresholds, Medicaid rules, they change constantly. And nobody from the government is going to call you and explain what those changes mean for your house or your retirement. That is exactly what this channel is here for. Subscribe and turn on the bell so you catch every update. Now let's talk about the fourth document, because this is the one where the state government is quietly waiting to make decisions for your family if you do not act first. If you die without a will in the United States, your state decides who receives your property. The legal term is dying intestate, and the rules are not what most people expect. In Texas, if you die without a will and you are married, your surviving spouse only inherits 1/3 of your separate property. The remaining 2/3 go to your children, even children from a previous marriage who have had no relationship with your current spouse. In California, depending on the circumstances, a surviving spouse may only receive 1/3 or 1/2 of community property. In Pennsylvania, the first $30,000 goes to the spouse, and everything beyond that gets divided. The pattern holds across all 50 states. The government assumes it knows better than you how your property should be split, and without a written will, the government wins every time. A basic will costs between $200 and $800 to draft with an attorney. There are lower cost online options, but if you own a home, I would not rely on a cheap generic template because the language around real estate transfers has to be specific to your state. More importantly, a will has to be updated every time something significant changes in your family. Take a man like Robert, 68 years old, retired machinist from Akron, Ohio. He wrote his will in 1997, never revisited it. The executor he named died years ago. He has grandchildren who were not born yet when he signed it. His second wife is not named. When Robert dies, that outdated document creates a legal dispute that drags on for over a year and costs the family more than the will was meant to protect. Every will needs a review every 5 years, and immediately after any major life event. An outdated will can sometimes be worse than no will at all, because the family ends up in court arguing over which version controls while the house sits there bleeding money. Now we are at the fifth document. This is the one I told you about at the beginning, the one 9 out of 10 seniors never file, and the one that costs families more than almost anything else on this list. If you only take action on one document after watching this video, make it this one. It is called a durable power of attorney for finances. This is the document that names someone you trust to manage your money and your property if you become unable to do it yourself. If you have a stroke, develop memory problems, or end up hospitalized for an extended period, this is the document that allows your spouse or your child to pay your bills, manage your accounts, and handle anything related to your home. Without it, your family cannot legally do any of those things. They cannot touch your bank accounts, they cannot pay the mortgage, they cannot sign anything. To get that authority, they have to go to court and ask a judge to appoint a guardian or a conservator. Let me do the math live so it lands. A guardianship proceeding in this country costs the family between $3,000 and $10,000 in legal fees just to get the appointment. After that, the appointed guardian has to file annual reports with the court, which often runs another $2,000 to $4,000 every single year. But the money is not even the worst part. The proceeding takes between 3 and 6 months to complete in most states. During those months, nobody can pay your property taxes, nobody can authorize repairs to the house, nobody can sell it if you need to move into a care facility. And the bills do not stop for anyone. Families lose homes to foreclosure during guardianship proceedings every year in this country, and a single document filed on an ordinary afternoon costing between $100 and $300 and about an hour with an attorney would have prevented every one of those losses. But here is what makes this so urgent. A durable power of attorney can only be signed while you are still mentally competent to sign it. The moment a doctor questions your capacity, that window closes permanently. You cannot sign it from a hospital bed. Your children cannot sign it on your behalf. Once that moment passes, the only path left is the courtroom, and by the time you get there, the damage is already in motion. The sixth document is the one that is costing you money right now, this month, and probably has been for years. It is your homestead exemption filing. Almost every state in the country offers a homestead exemption to homeowners, but the savings and the rules are completely different depending on where you live. In Florida, the exemption removes up to $50,000 from the assessed value of your home for property tax purposes and caps how much your tax bill can increase each year, no matter how much the home's market value climbs. In Texas, as of 2024, the exemption removes $100,000 from the assessed value of your home for school district taxes alone. For most senior homeowners, the annual savings range from $1,000 to $3,000 per year. Over 20 years of retirement, that is between $20,000 and $60,000 that stays in your pocket instead of going to a county tax office. Here is what most seniors never realize. In many states, the homestead exemption is not automatic. You have to file a one-time application with your county tax assessor's office. After that, the exemption stays in place for as long as you own the home. The application is usually free and takes about 15 minutes. On top of that, many states offer an additional senior exemption that kicks in the year you turn 65, an extra $5,000 to $15,000 in tax savings over a lifetime, depending on the state. Almost nobody who qualifies for the senior exemption actually files for it. The county does not send you a letter. You have to know to ask. Now you know. Here is what I want you to do this week. Start by finding the deed to your house. It is in your filing cabinet, your lockbox, or your county recorder's online portal. Write down which of these 6 documents you already have and which ones you do not. For any document you do not have, search its name along with the name of your state and read what comes up. Then call in a state attorney in your county and ask for a 1-hour consultation focused specifically on home protection documents. That consultation will cost between $200 and $400, and in that hour, the attorney will tell you exactly which of these 6 documents you need based on your state, your family situation, and your home's value. And I want to leave you with this, because it is the piece that matters most. Every one of these documents has a window. Every one of those windows closes the moment something happens to you. Once you are in the hospital, once a court gets involved, once the state steps in, none of these forms can be filed. They cannot protect what they were not given the chance to protect. The action has to happen before the emergency, not during it. I am not an attorney, and nothing in this video is legal advice. This is education, and it is meant to point you in the right direction. So you walk into that attorney's office already knowing the right questions to ask. Now, I want to hear from you. Which of these 6 documents do you already have in place, and which ones did you not know about before today? Drop it in the comments. I read every single one. And if you have a parent, a sibling, or a neighbor who owns a home and does not know this information, do them the favor of sending this their way. It could be the most important thing that lands in their inbox this year.